Phyllis Richardson had allegedly embezzled nearly $1 million during the decade that she worked for Community Savings Bank. The United States indicted her on 41 counts, including embezzlement of funds of a federally insured financial institution, mail fraud, and money laundering. Not surprisingly, the jury at her 6-week-long trial had some trouble understanding these complex financial topics. The court's decision to let the jurors submit their own questions to witnesses led to Richardson's appeal in United States v. Richardson. At the beginning of Richardson's trial, the judge instructed the jury that if they didn't understand a witness's testimony, they could submit written questions after the lawyers finished their examinations. The judge would review the questions with the attorneys and then pose any acceptable questions to the witnesses so the jurors could hear the answers. The judge explained that some questions might be improper under the rules of evidence and instructed the jurors not to speculate as to why some of their questions weren't asked or answered. Richardson didn't object to this practice at this point. Throughout the trial, jurors occasionally wrote down questions for witnesses. The court would review the questions with the attorneys and then address any that passed muster to the witness. The jurors had submitted 10 sets of questions for witnesses when, mid-trial, Richardson objected to allowing jurors to pose their own questions. She argued that the jurors were becoming adversarial and engaging in premature deliberation of her case. The court overruled her objection, but instructed the jury that they weren't to become advocates and that they could ask questions only to clarify a witness's testimony. After this objection, the jurors submitted another 13 sets of questions. The jury found Richardson guilty. Richardson appealed to the 11th Circuit. She argued that allowing jurors to submit written questions to witnesses through the court had denied her a fair trial.